all, I'd like to introduce Conor Casey. And Conor is a Max Weber postdoctoral fellow at the European University Institute in Florence. He graduated with first-class honours from Trinity College in Dublin 2015. He has a master's degree from Yale Law School, and he is almost ready to say he has a doctorate. He's just submitted his PhD thesis for examination, and he has his Viva next Friday, for which we wish him all the best and to enjoy. So I'm going to hand over to Conor, who's going to talk about the topic of Irish constitutional law and how it's engaged by the current lockdown. So the floor is yours, Conor, and I'll give you a thumbs up when you have 5 minutes left of the 15-minute presentation.
Thanks very much, Brenda. I'm just going to share this PowerPoint I have prepared. So thank you very much for the introduction and for being invited to speak. There's always a cliche that every speaker says that, you know, this is a very timely kind of event. Unfortunately, it absolutely is. But I was saying to Anne at the start that I look forward to the time when these conversations are truly academic. So I'm going to talk about the constitutionality of the current iteration of Ireland's lockdown. And I'm going to do it through asking three questions. So first, I'm going to ask whether the Health Act 1947, number 8 regulations, those are the current regulations implementing the lockdown. Those were issued by the Minister for Health. Are those regulations within the scope of the statutory authority delegated to the Minister by the Oireachtas under the Health Preservation and the Public Interest Act 2020? If that answer is yes, then is the Health Act 2020 itself, the act that delegates the power to the Minister to make these regulations, is that a constitutional delegation of statutory power by the Oireachtas, or does it offend the vesting of lawmaking in the Oireachtas? And if the answer to that is yes, if that's constitutional, finally, I'll ask, is the Health Act regulation, the number 8 regulations that are in effect, could we argue they're an unconstitutional infringement on fundamental rights? So I won't leave you in too much suspense about my answers to these questions. I'll front load that at the outset. I think the answer to the first two is yes, they're both constitutional from those structural perspectives. And then finally, on the third point, I'll argue it's very unlikely that a court would find the lockdown regulations an infringement on constitutional rights, but we'll go into more detail, obviously. On the first question, is the current iteration of the Health Act 1947 number 8 regulations, are they within the statutory power delegated to the Minister by the Oireachtas? So we need to start with the Health Preservation and Protection of Health Act 2020, passed by the Oireachtas in April time, when the pandemic was starting to be exacerbated. This act provides for a very sizable grant of statutory authority to the government, most notably through the Act's amendment to the Health Act 1947, which is sort of the framework statute in Ireland for regulating infectious diseases. It used to be used for things like tuberculosis. So the 2020 Act amends the Health Act 1947. In particular, of particular importance, Part 3 of the 2020 Act amends Section 31A. It inserts Section 31A into this old Act, the Health Act 1947. And this Section 31A amendment confers on the Minister for Health power to make regulations for preventing, limiting, minimizing, or slowing the spread of COVID-19. And specifically, it grants them authority to do any of the following. So, to prohibit travel to or from the state, prohibit travel within the state, require people to remain in their homes, prohibit events that could reasonably be considered risk of spreading it, or shut down businesses, or stipulate standards businesses need to adhere to in order to remain open. So very capacious authority indeed, delegated to the Minister to make regulations. So that Section 31A of the Health Act, as inserted by the 2020 Act, That is the statutory source of the minister's ability to make regulations, and that's the statutory authority he used to create these regulations, giving effect to the current level 5 lockdown. So the main sort of effects of that regulation are that people are essentially not allowed to leave their place of residence without a reasonable excuse. And reasonable excuse, there's specific sort of carve-outs in the regulation of what constitutes a reasonable excuse. For example, exercise within 5 kilometers, going to work if you're not able to work at home, to attend university or school for medical reasons, or to go to the shop for essential items. Other aspects of the regulation include a sort of prohibition on organising events in your premises except with your household or one other household you can pair with. And it provides essentially that businesses in general must either shut unless they provide an essential service or they're an essential retail service as defined in the regulation. So very sweeping sort of regulation and engagement with civil liberties. So is this regulation within the scope of the statutory authority given by the Oireachtas, or is it ultra vires? So I say I really doesn't seem to be ultra vires. It seems well within the statutory power of the minister, the statutory authority delegated by the Oireachtas to issue regulations. As we've seen, Section 31A of the Health Act 1947 is strikingly capacious and sweeping in the authority it gives to tackle the pandemic. It's probably one of the most sweeping statutory delegations of power I have seen, and probably the most that has existed outside of wartime, outside of the emergency in the 1940s. So that's the first thing. The regulation is within the statutory scope of power given to the minister. Second, is the delegation affected in the Health Preservation Act 2020? Is that within the constitutional power of the Oireachtas to delegate? Or is the delegation too broad? Does it represent a breach of the Constitution's vesting of lawmaking power in the Oireachtas? I'm going to assume some basic familiarity with principles of Irish constitutional law in this next part, but I'll give a very brief primer. So the Oireachtas obviously is not expected to regulate every single issue in a complex regulatory state like Ireland. So it can delegate statutory authority to make rules to the executive. But the courts have said that it can't give away too much discretion to make rules, because if they give away too much discretion, the courts think they would be delegating away their sole and exclusive power of making laws, which is given to the Oireachtas alone in Article 15, to the Parliament alone. So the courts have said you can give away statutory power to make rules, but the Oireachtas needs to speak to the objectives and policies they want the person delegated power to make rules to address. What objectives and policies is this delegated power supposed to be directed towards? So the courts have a test called the Principles and Policies Test, which separates permissible and impermissible delegations of statutory powers to make rules. The leading case at the moment is a case called Betterev, Minister for Justice. And what the courts essentially say is that the Oireachtas cannot delegate a blank check to make rules. The Oireachtas, in the statute delegating power to make rules, must place limits and guidance on the delegated statutory power, so that it's not just a sort of giveaway of a power to make rules that would be an abdication of legislative responsibility. So the Oireachtas has to speak to some degree about how it wants the power to be exercised, what goals and policies motivate the delegation of power, and what principles should be factored into how the regulations are to be formed and the policies behind it pursued. So how does the Health Preservation Act stack up against these requirements? I think it comfortably passes this requirement. So Section 31A is inserted into the Health Act 1947, is truly capacious, as we talked about, but that same section also requires the minister to have regard to several factors in making regulations, which essentially ensure that it's not a blank check. So if you read Section 31A, it says the minister, when making regulations, has to have regard to the fact that there is a widely acknowledged that COVID-19 is a pandemic, a worldwide pandemic, extremely infectious, extremely dangerous. The minister is to have regard to scientific evidence and expertise, both Irish, can have regard to European developments, or the guidance coming from the WHO. The state has to have regard to its moral duty to protect life and health of its citizens, and in forming regulations has to have regard to financial implications any response might have on the state. So taken cumulatively, this list of factors, these principles and policies do provide limits on the discretion of the executive to issue regulations, and ensure that it is not just a blank check for the government to issue regulations preventing travel or preventing businesses from opening whenever they want. It really is the Oireachtas saying this is for a particular kind of policy problem, and it has to also be addressed in a particular kind of expertise, scientific-led manner, and it has to have regard to sort of financial implications as well. So you could think, I think it's very outlandish, but these limits ensure, for example, if we had a situation a year from now when there was a vaccine and the pandemic had been sort of flattened, and there was no discernible benefit in terms of saving life or hospital capacity for a lockdown, and the government tried to bring in a lockdown, and it was the health was pretextual. Maybe the reason was just crime control or some crazy reason like that. That regulation would be ultra vires, because the purpose of issuing regulations has been made clear by the guidelines set by the Oireachtas. If all those guidelines and factors weren't there, and it was just a power given to the government to create a lockdown, and it wasn't linked to tackling a pandemic or the need to protect life and health or financial implications, or have regard to scientific evidence, it would have probably very likely been a breach of the principles and policies test. So because it has these guidance and limits, I would say that it is constitutional in light of that test. Okay, so those are sort of the structural legal concerns. Is the regulation within the scope of the power delegated? And in turn, is the delegation constitutional? I say the answer is yes. So the final question is the regulation implementing the lockdown, preventing us from traveling or organizing events in our house, is that an unconstitutional interference with rights or not? So before answering this question, we need to first discern which rights, if any, are implicated. I think several plausibly are implicated. Privacy is a right protected in Article 40.3. Privacy is engaged because we can't just do what we want in our homes. The activities, how many people we have in our homes, are now regulated by law. I think that engages it. Liberty, we can't just go about our business peaceably. There are limits to how far we can go from our houses. Same with the right to the inviolability of the dwelling. It sort of links into what I said about privacy. Freedom to assemble, we can't meet up with how many people we want peaceably. And probably even property, in the sense that the shutting down or heavily regulating what businesses can do might cause a serious depreciation in their value, and that could implicate property rights. So the rights are probably definitely engaged. So if you're saying my right has been engaged with this regulation, I think it's unconstitutional. How would a hypothetical court approach determining that issue? So the court would apply a test called a proportionality test that was adopted in Heaney in Ireland to discern whether it's a permissible or impermissible regulation. There's 4 limbs to the Heaney test. The court will ask, does it have a legitimate objective? In this circumstance, you'd say yes. Does the legislation regulating the right have a legitimate objective? You would say yes. The regulation in this case is to save lives and prevent spread of a deadly disease. You couldn't think of a more legitimate objective. Is the means are the means rationally connected to this objective? Well, preventing people from traveling, interacting is a good way to stop a disease passed on from person to person contact. So yes, rationally connected. Are the means no more than necessary to achieve the objective? You could probably argue strongly here that this is sort of a last resort, and it's the result of trying graduated measures that didn't seem to be achieving the desired effect of curbing the pandemic. And then finally, is the extent of the engagement and regulation of the right proportionate to the good to be achieved? And this is a very tricky, essentially a moral political value judgment, and it asks, is the extent of the engagement for rights, civil liberties, etc., is it proportionate in light of the lives saved and the strain on social solidarity avoided by allowing this pandemic to sort of continue unopposed? It's a very tricky call to make, but there's good reason to think that, and this ties in the second strand of how a court would approach this issue, there's good reason to think that judges would offer very considerable judicial deference to the Oireachtas and the government's assessment of the necessity of a lockdown measure. And there's two reasons for this. The first is that this decision involves very tough moral and political value judgments in balancing, frankly, incommensurable values like life, health, liberty, and state finances. A court is only going to understandably say these are very tricky, not very legal calls, and if moral decisions have to be made, they should be left to branches that are accountable to the people. Judges are not accountable for the decisions they make, whether people die or not because of striking down a regulation. That is not a burden that a judge would want to bear lightly. So that's one reason. And the second is that these policy responses had input from very experienced civil servants who trained their whole life essentially to get to grips with epidemiology and scientific study of public health issues, and input from civil servants trained in finance and things like that. So very, very complex scientific technical knowledge. Courts do not have the same expertise, so they might feel very ill-equipped to second guess these determinations and balances made. A court only addresses these issues through affidavits and in the context of litigation over a couple of days. So a court might feel very ill-equipped to second guess. That's why I think that, considering the proportionality test and the reasons for deference, a court would essentially say that any engagement was constitutional and proportionate. So in conclusion, I would say it would be extraordinarily unlikely a court would find the regulations unconstitutional at present. But on a final point, if the situation changed dramatically, so this time next year there was a vaccine and there was essentially obviously no scientific basis for a lockdown, and no one thought there was any benefit for it, and you try to do it again, probably then it'd be unconstitutional, but for the moment it would be extraordinarily unlikely to be found unconstitutional. Well, so thank you very much for listening. That's my presentation.
Okay, thanks very much, Conor. I'm not sure if you were able to see my thumbs up and my. So our second speaker is from Maynooth University. So I'd like to welcome Ollie Bartlett. So Ollie's an assistant professor of law at Maynooth University. He was awarded his PhD from Durham University and had lectured at Liverpool University before coming over to Ireland and joining Maynooth in 2018, August 2018. So Ollie's interests are in and around the area of EU free movement law and regulatory law. So I think he's going to talk a bit more about the EU approach and the Commission recommendation in respect of restrictions in free movement and how it should be interpreted in light of existing free movement law. So the floor is yours, Ollie. I'll try and give you a thumbs up whenever there's about 5 minutes to go to keep things running smoothly. So the Zoom's all yours.
Great, thank you very much indeed, Brenda. Unfortunately, I haven't got a fancy PowerPoint. I decided to go fairly old school. So that means on the plus side that I will be able to see your thumbs up, Brenda, when it does inevitably come. I shall try and keep myself to time as much as I can. So yeah, as Brenda said, I was going to talk about the legality of these stay-at-home travel restrictions, these 5-kilometre travel restrictions under EU law. Okay, so hopefully providing a bit of a sort of alternative perspective to Conor's excellent presentation. So as people might know, on the 20th of October, I believe it was, the Irish government agreed to align its policy on travel with the EU Commission's recommendation on a coordinated approach to restrictions of free movement. This is a non-binding document, and it's supposed to provide a sort of a template for all member states of the EU in relation to the design of COVID restrictions, which impacts the free movement of EU citizens. It is primarily intended to generate some consistency in how member states restrict the movement of EU citizens who want to enter their territory, right? Nationals of any of the member states are also EU citizens, and so therefore they have the right to move freely between the member states. And anything that makes that more difficult is a restriction to that freedom of movement, and so must be justified in accordance with the general principles of EU free movement law, specifically the principles of proportionality, which Conor's already talked about in the Irish context, and non-discrimination. My cat is screaming from the other side of the closed door, which is fairly distracting. I'm sorry if people can hear it. So back to this. So with the recommendation, the Commission has sought to bring some consistency to how the member states are all restricting EU citizens' freedom of movement in pursuit of the objective of protecting public health, which obviously EU law also recognizes as a legitimate reason to restrict free movement, so long as the general principles of EU law are complied with. So the purpose of the recommendation, the stated purpose, is, quoting, to facilitate the application of these principles, the general principles, in a coordinated manner to the exceptional situation caused by the COVID-19 pandemic. So in other words, with this recommendation, the EU Commission is asking member states to sign up to common criteria for restricting EU citizens' free movement rights, essentially during the COVID pandemic, to ensure that the enjoyment of any particular EU citizens' free movement rights are not wildly different, right, simply by virtue of where they happen to be living in the EU at this time, right? And of course, this goes to the heart of what the EU is all about. You know, all EU citizens should enjoy the rights that they are granted by EU law equally. So that's what this recommendation is all about. And obviously the consequences of not having a common approach are kind of obvious. And those are also stated in the recommendations to do with disruption to business and citizens' lives and so on and so forth. So that's the recommendation. And while it's designed to coordinate member state restrictions to free movement that are imposed on travel into a member state, right, that's primarily what it's designed for. Nevertheless, EU free movement law could still apply to restrictions that member states impose on travel within their territory. And I think that was more the brief that I was kind of asked to cover. So that's what I'm going to talk about here. Now, there is a strong argument, of course, that EU law shouldn't apply at all to the movement of Irish nationals within Ireland, right? The Court of Justice's case law makes very clear that that's what's called an internal situation, right? Where there's no cross-border element, which doesn't therefore fall within the scope of EU law. However, obviously for the very many non-Irish EU citizens who are living in Ireland and who have triggered the application of EU law by virtue of exercising their rights to move, live and work here, then obviously the question of whether the Irish restrictions on travel within the state are a breach of EU free movement law, right? And that's then relevant for them, okay? So that's why it's relevant for me and us here. So, of course, travel restrictions undoubtedly hinder the rights of EU citizens to move freely within the territory of the EU, which would include the territory of one of the member states. Now, whatever it is, a 5-kilometer limit or indeed a 1-kilometer limit, for instance, as recently was imposed in France, that makes moving around as you want, you know, quite difficult. And the settled principle is that anything that makes movement more difficult is sufficient to breach the free movement rights granted to EU citizens under Article 21 of the TFEU. However, then member states have the opportunity to justify such restrictions, again, in a similar manner to what Conor was talking about. And in the case of the free movement of persons in EU law, there are 3 grounds of potential justification set out in the Citizens' Rights Directive, that is public policy, security, and health. Of course, public health is the obvious ground of justification for these COVID travel restrictions. So the Commission's recommendation, right, re-emphasizes what is required by EU free movement law generally in order for justification to be established for these kind of restrictions, which is that any travel restrictions adopted by the member states must be strictly necessary to safeguard public health, and they must be compatible with general principles of proportionality and non-discrimination. So I'll spend the rest of my time just exploring these criteria a little bit. So strictly necessary, as it's referred to in the recommendation, I think refers to the proportionality of the restrictions, not to the scope of the public health justification, right? Clearly preventing the spread of COVID-19 falls within the scope of protecting public health, as is obvious from the Citizens' Rights Directive as well. In any event, the scope of the public health justification is, I think, quite wide, certainly wider than the public policy and public security justifications. And although the case law consistently refers to the fact that public policy and security must be interpreted strictly, there's no mention of that for health. So it's quite a broad ground of justification. Now, needless to say, no public health situation like COVID has ever been considered under EU law before, at least not exactly this. In fact, there is quite little case law on the restriction of the free movement of persons on grounds of protection against infectious diseases. So there's no real precedent, as far as I can tell, as to what a proportionate restriction might look like under EU law in these exact circumstances. So therefore, of course, we might draw some comparisons and infer a few things. So probably the closest comparable situation is the BSE crisis back in the early 2000s or late 1990s. There's the mad cow disease crisis, and the question was raised about the proportionality before the courts, right? The question was raised about the proportionality of a commission decision that banned the export of bovine products from the UK. So not exactly the same, but similar sort of issues of free movement are at stake. And the CJEU held that such an action is proportionate given the conditions of emergency and scientific uncertainty that existed at the time. So setting a precedent that, restricting free movement to guard against infectious disease could in principle be proportionate, okay? And this kind of linked the idea of proportionality to the precautionary principle, okay? Under the precautionary principle, member states are allowed to protect public health in whichever way they want if the conditions of scientific evidence that exist at the time are sort of equivocal. So obviously now the conditions are not really the same here. We're still dealing with conditions of emergency, right? Public health emergency. But I think there's a little more scientific, there's a little less, scientific uncertainty about the spread of COVID, right? As there was about BSE, I think, at the time. And of course, this relates to the movement of citizens and not to goods. So the proportionality concept is obviously the same, whether it's applied to restrictions on goods and to restrictions on people, which is, as I think Conor already sort of preempted this bit of my presentation, which is that the restrictions must be, in order to be proportionate, they must be appropriate to the objective of protecting public health and necessary to, thank you, yes, I can see that there, excellent, thanks Brenda. They must be appropriate to the objective of protecting public health and necessary to achieve those objectives. So in other words, restrictions on free movement for the purposes of protecting health must be capable factually of protecting public health, and they must be the least restrictive of a range of potential restrictions if there is more than one option for effectively protecting public health. Now, in the case of COVID restrictions, I think it's obvious that travel restrictions are factually capable of protecting public health. So that leads us to focus on their necessity under the proportionality test as it's set out in EU law. And here, I think comparing to the BSE crisis, okay, where those kind of restrictions on movement were found to be proportionate. The issue of evidence and scientific uncertainty, I think, becomes important in assessing the necessity of any travel restrictions that member states impose. Now, many cases before the CJEU that concern the proportionality of restrictions that are potentially justified on public health grounds have emphasized that member states have this margin of discretion to determine how they would like to protect public health. However, member states must produce actual evidence, right, to support the fact that restricting free movement is necessary. Many of the cases do link this, the outcome of this necessity review, to the state of scientific evidence on the issue. So, in other words, member states can usually do what they like to restrict free movement in order to protect public health, but they must show some scientific evidence to support why that restriction and not some other lighter measure is needed, okay? Now, it is plausible that the necessity review of member state travel restrictions to protect against COVID should be subject to a slightly stricter proportionality review, on account of the evidential situation that we find ourselves in. I mean, the case law on public health justifications doesn't generally insist that member states produce any specific type of evidence to justify restrictions that aim to protect public health. However, in this recommendation, the Commission places on record that there is certain acceptable evidence that must support a restriction of free movement in response to COVID, and that consists of the 14-day cumulative case notification rate, the test positivity rate, and the testing rate, right? So it's not immediately clear from the text of the recommendation itself whether these are the only pieces of evidence that member states are allowed to rely on in implementing restrictions, or whether these are just the best examples. The feel I get is that these are the only 3 data points that member states can take into account. So what does all that mean? It means, therefore, that any proportionality review of a member state travel restriction, like we're looking at here, may be slightly stricter than has been applied in the past, by virtue of this fact that the evidence required to support the necessity of the restrictions is already specified. It's out there in the public domain. Now, the current travel restrictions, I think, would probably meet the threshold of necessity under EU law, right? They are effective. They're the only real solution to prevent widespread transmission of COVID. And crucially, these most recent restrictions do seem to have been taken after the epidemiological situation worsened in Ireland. So we do have kind of quasi-experimental evidence for their necessity. The stats that are usually given to support the imposition of these travel restrictions here routinely involve the kind of 14-day incidence rate and the positivity rate. So I find that there seems to be little to suggest that the Irish travel restrictions would be a disproportionate restriction of free movement under EU law, even despite this potentially slightly heightened proportionality review. So I'm going to 1 minute from Brenda. Yeah, so I'll probably just move on to say a few things about. So in other words, I'm not sure that these restrictions that we see here would be deemed to be disproportionate as a matter of EU law. But what about the non-discrimination principle? And I'll deal with that just very briefly, Brenda, if you don't mind. So in essence, the other general principle that these measures must be compatible with under EU law is the non-discrimination principle. That means that these government travel restrictions should not apply differently, whether as a matter of law or fact, to people based on their nationality, right? Thus, for example, the government here can't devise a rule that specifically restricts travel for people of a particular nationality, or a rule that applies to every person but which has a particularly burdensome effect on people of certain nationalities, right? So again, I think it's hard to see how these 5-kilometre travel restrictions applying to the whole of Ireland could be discriminatory in any way as a matter of EU law. Sure, there is an argument that restricting the movements of people living in Ireland to within 5 kilometers or whatever it is, for all but essential reasons, could impact non-Irish member state nationals who want to travel for non-essential reasons more than it would impact Irish nationals, given that non-Irish nationals living here might have more reason to travel outside of the state. But then once we start talking about leaving the state, then Ireland's rules cease to be the issue, right? The issue then becomes the rules on quarantine in the person's home state, right, to which they're traveling. Now, Ireland can't, as a matter of EU law, Ireland can't prevent nationals of other member states from leaving our territory, right? For example, a Spanish national living in Ireland who wanted to return to Spain for like a non-essential reason, Ireland couldn't prevent that person from leaving. The issue then becomes what are Spain's rules on self-isolation, for instance, if they're going back to Spain, for incoming travelers, and whether or not those are discriminatory in any way, as well as whether they're proportionate. I'm nearly done, Brenda, so I'm just finishing off. But I think, again, like if you're looking at the rules in another country, then I think it's difficult to say that those rules are discriminatory if they do apply to everyone. For instance, the rules would be just as burdensome on that Spanish national returning home as they would be, say, on a French tourist going to Spain. So I do think it's hard to see how the non-discrimination principle could apply as long as these restrictions are applied to everyone in the Irish territory as they are. Coming back to our travel restrictions, our local travel restrictions here, if we're not talking about leaving the state and merely traveling within it, there appears to be little, I think, to indicate why these would be discriminatory against, discriminatory on grounds of nationality. They don't really seem to impact anyone particularly differently just purely because of their nationality. So therefore, in summary, just to draw everything to a very, very quick close, I don't see any reason why the travel restrictions imposed here for travel around Ireland would be incompatible with the general principles of EU free movement law, which is my basic conclusion. There are loads of other interesting aspects of the recommendation that I do think are worthy of further study. And the one that I really want to get into soon is the power that seems to be given to the ECDC, the European Centre for Disease Control, the power given to them under this recommendation to essentially decide what happens with cross-border travel in a sort of shady backroom agency type way. But obviously that's for another time. So hopefully I've managed to accomplish the brief that I was set out, which is to say whether or not these rules are legitimate under EU law, which in a very roundabout way, I hope I've said, yes, they are perfectly fine as far as I can see as a matter of general principles of EU free movement law. So that's me. I'll pass back to Brenda, and apologies, I abused my time there.
Okay, thank you very much, Ollie, and thanks, Conor. So I just want to, I suppose, a round of applause for both of our speakers before I open up for Q&A. Whether you want to give a virtual round of applause or a physical one. So thank you very much. To really interesting papers, and I think there's lots of opportunity for discussion. And I suppose there's it's kind of interesting to see, I think, on the island of Ireland, that whole discussion debate around restrictions and public health restrictions and the question of the border. I think there's a live TD, it was reported in the journal.ie, who had raised concerns about the number of people travelling across the border from Northern Ireland into the Republic of Ireland, despite the fact there's quite tight 5-kilometre restrictions in the Republic of Ireland, whereas those restrictions don't apply in Northern Ireland. And I suppose different people have concerns about that in respect of the spread of the disease as well. But I'll open up for questions rather than abusing my role as moderator and chair and taking over. So I'll open up to the floor if there's any questions. If you want to type them into the chat box, or if you want to stick your hand up if you have a question you want to ask any of the speakers. I don't see any hands. Okay, I've got one question coming through from Annalika. And the questions for Conor. So how is essential defined? So Annalika has indicated that she's surprised by the allowance of supermarkets to have flash of various goods that were certainly not essential. So that question's for you, Conor. So if you want to unmute yourself.
The regulation, the number 8 regulation, which sort of gives concrete effect to the lockdown, is it's 35 pages long. I'm just looking through it here. I think they do make an attempt to define in a sort of, yeah, here it is. So they don't give an exhaustive definition. In fact, they include items like food, beverages, fuel, medicinal products, medical devices or appliances, essential items for the health and welfare of animals, or supplies for the essential upkeep and functioning of the person's place of residence. That's how they define essential, but again, not exhaustive. And you'll remember on there was sort of a bit of a furore on RTE whenever Damien English, TD, Minister for State, was asked whether children's socks, children's clothes were essential items, and he didn't quite know how to answer that, because on the one hand, the regulation is not framed in a sort of exhaustive way. Those are sort of illustrative items, but at the same time, he didn't want to go out on a limb and say that would be. So the answer to the question is that it's not, there's an ambiguity, and I think it's an unavoidable ambiguity of trying to issue a regulation that is both strict but also not harshly implemented. And I would say that how it's enforced will turn on how the Gardaí are probably instructed to enforce it at a retail level. And that could go well or badly depending on whether the guidelines given to the Gardaí are uniform, consistent, or whether they're left to sort of arbitrary decision making, which I think brings up a host of tricky issues. Are the Gardaí going to enforce what's essential in a strict way against a certain demographic of person as against another? It shows, I think, that in an area as tricky as this, there may be a gap between the law on the books and the law as implemented, and that can be either a good thing, it could be constructive ambiguity, where it's sort of there to sort of encourage people to be as cautious as possible getting things, but it leaves some oil in the joints so that you can, so it's not super strict, or it could be enforced arbitrarily. So I think the scope of essential is not known fully, and it remains to be teased out by authorities enforcing or not enforcing it. I think we will see how that plays out in the next few months, really, or next few weeks, depending on how long the regulations are kept in effect.
Okay, thanks. Someone had their hand up.
Well, Ollie, do you want to start, or?
Well, I mean, I think that this, I mean, exactly like you said, I mean, I think that there has to be a certain amount of flexibility in the legislative drafting here, and there's always going to be certain things that are in the grey zone for what isn't allowed. And of course, I mean, we see that in this latest round of lockdown, restrictions, the visiting of, grave sites and the visiting of grave sites was included in the list of essential travel, whereas I don't think it was in the last round. So we see a kind of evolution of what is and what isn't, essential reasons. I don't think I'm aware of the specific example that you're giving there, but certainly as far as the EU restrictions are concerned in traveling, I mean, I'm looking at the document now. I mean, travel across borders for things like it says again, and this is where again, Conor's point about the looseness of the drafting, it says imperative family or business reasons. Now, what imperative means could well include aspects of burial and cremation and so on and so forth. But again, I think it's probably undesirable that courts do get involved to make hard and fast rules as to what is and what is not permissible, especially around these very sensitive matters, you know. So I think that we will essentially see a kind of political evolution in what isn't acceptable, a little bit along the lines of the whole children's socks, you know. One TD says something that caused a lot of outrage, and then all of a sudden, you know, the underwear section in Duns is unfenced all of a sudden, right? So I think things will evolve that way, and I hope they would do, rather than by going through the courts, because that's a very sort of hard and fast way of making these kind of definitions.
Yeah. I mean, the funerals are mentioned in Ireland in the regulations to the extent that they put limits on them. So reading that in light of the imperative point Ollie just mentioned, it would seem that, you know, funerals are fine as long as they're limited, as are weddings are fine as long as they're limited. But it's very easy when you're talking about these. I know that the question might begin on a legal basis, but then it's so easy to see how it aligns into a sort of moral question. Well, why are you allowing a carve out for a wedding and not visiting in hospital, or I think you are permitted to go to hospital, or why a wedding and not some other kind of gathering which might be important to people? But then you're getting away from whether it's constitutional or not, and getting into sort of, you know, more openly normative questions about, you know, how we should allocate risk and things like that. And there's no sort of legal answer for that.
Mm-hmm. Okay, thanks both. I have another couple of questions that have come through to me in the chat box.